on the space-time continuum depending on where you are in the world. This means the official start of Ask Andrew is just nanoseconds away. Good evening, everyone. I'm Andrew Feldstein. I'm the Andrew in Ask Andrew. I'm also the founder of Feldstein Family Law Group. I believe Ask Andrew is the first internet phone-in show created by a family law lawyer. I'm here to answer your questions. I will give you lots of legal information for free, and many people tease me. Doesn't everyone want to talk to a lawyer for free? I know there are lots of questions about separation and divorce. This is our February program. Tonight, I'm in my own office in Markham, Ontario, just north of Toronto. Feldstein Family Law Group has other offices in Vaughan, Mississauga, Oakville, and the Bloor West Village area of Toronto. Ask Andrew will be most useful for people in Ontario. But because of the national nature of the Divorce Act, most of what we discuss will be useful across Canada. Our firm practices family law exclusively. Our goal is to get the best deal possible for our clients. Best deal means one that is legally binding. It won't come back to haunt you. And best deal means one that takes into account the best interests of your children. If kids are involved, I keep telling my clients, love your children more than you hate your spouse. And the best deal lets our clients get on with their lives instead of fighting for years. All combined, our lawyers have decades of experience. We take our work very, very seriously. Here's how tonight's question and answer show works. Some people have emailed their questions ahead of tonight's show, and we welcome more tonight. You can phone, which means we can discuss your situation. All you have to do is call 1-800-498-3486, as you can see here on the screen. One of our staff will answer your call, ask the general nature of your questions, perhaps help you phrase it, and decide on whether you wish to use your real name. You can send us a text, which is right here, 819-307-0262. Please note, it's a new text number and it's different from our previous shows. Lastly, you can send me an email directly to my laptop, and that's at andrew@feldsteinfamilylaw.com. We will not show your text or email on our screen. There's some technical things you should know about. It's a good idea to phrase your question carefully. Here's why. Each Ask Andrew show is recorded by YouTube, and you'll be able to go back and watch the show anytime you want. Bottom line, your question will be around for a long time. Please do not ask a question in such a way that it can identify you. Keep your safety and security in mind. Let's get started. Okay, as I said before, we have some questions that people have texted to us previously in anticipation of this show. So I'm going to get started. I hope that we'll have some callers call in the near future and we can have some interaction with them as well. Now, the first question came in from Nancy, and I'm going to start with one that came in today. And Nancy says, I do not have my husband's resident address for the last 6 years. I have his work address recently from his lawyer. He will retire this year. I want to know, do I have good reason to ask for lump sum alimony, because I don't think I could get a hold of him after you retire? Also, how are lump sum alimony calculated? It's a very good question. And where I start with is alimony, we call here in Canada, spousal support. Lump sum spousal support is only ordered in very rare cases in family law. Very rare cases. People sometimes negotiate it because someone says, I'll give you one payment and then I never have to pay you again. So there's a reason why some people may want to do it. In those cases, there's risks, because if you're making that lump sum payment, are you actually going to make the money you think you're going to make? For the person who's getting it, are they going to make more? For the person who's paying it, are they going to make less or lose their job? But in this case, there's lots of questions in here, because somebody choosing to just retire does not necessarily mean that they no longer have to pay spousal support. Because when they retire, they're making a choice. They're making a choice that they're not going to continue working, notwithstanding they know they have that obligation to support their former spouse. Now, part of that will depend on their age, what assets they have, i.e., will they be able to generate an income stream from their assets? So if you have a 52-year-old payor who says, I want to retire, that's going to be tough. I think in that situation, if someone went to court and said, I shouldn't have to pay spousal support because I retired at 52, I think a court's going to say, not good enough. A court's going to say, you still have to pay your spousal support. And if you quit your job, tough luck. Go find another one. Now you contrast that with, say, a 70-year-old who retires. I think a court is probably going to say someone at 70 years old is entitled to retire. They're entitled to be done working. So in terms of the fear in this particular case, I don't think there's a rationale for lump sum support, but certainly sending the former spouse a letter telling them that you're not going to agree to a reduction in spousal support based on their retirement if they're too young or there isn't a good reason for it is a way to put them on notice that they're at risk, that you're going to say to a court, not good enough, and that they haven't established the material change. And a material change is the test. For someone to reduce support, they need to establish there's been a material change. And in this situation, you put them on notice, and this person will have to think twice about retiring. Now, we just received another text message that just came in, and I'm going to read the question. I am filling out my financial statement for my separation. Can I deduct the accrued tax on my cottage from the fair market value of the cottage? Why should I include the fair value? Now, when we have to determine equalization of net family property, and equalization of net family property is how we deal with the assets. And I'm going to explain what that is. Unless you hit one of the exceptions, you're looking at your net worth on the date of separation, less your net worth on the date of marriage, to see how much your assets grew by during the course of your marriage. You do that for both sides, and whoever has more pays half the difference to the one who has less. So if you take an example where one side has $1 million and the other side has $500,000, that's how much they grew by during the marriage, the difference is $500,000. The one who has more will pay $250,000 to the one who has less. That would equalize their property because the person who went up by $1 million pays $250,000, so afterwards they're up by $750,000, and the one who was up by $500,000 gets $250,000, and they're up $750,000. So they both are up by the same. It sounds simple, but then we get into lots of disputes over values of assets and liabilities. So in this situation, what I think the person who sent the text message is talking about, let's say they had the good fortune of buying a cottage property in Muskoka 10 years ago on one of the big lakes. And we could say they paid $1 million for it, and today it's worth $2 million. Well, that means when they go to sell that cottage, they're going to have $1 million of capital gains to pay taxes on. That means when it's a capital gains tax, half of it won't be taxed, so they're left with $500,000. And let's just use an easy tax rate of 50% on that. They're going to owe $250,000 in taxes on the sale of that cottage. So would the tax liability be included on the financial statement? And the answer is yes. But the argument would be, what's the appropriate tax to use? It's not just simply the calculation I did, because the theory is you may not sell that property for another 10 or 20 years. And the closer to the date of selling the property you are, the higher the amount of the actual tax rate you're going to get. So if you knew you had to sell the cottage as a result of the divorce, then you're going to get the full tax rate. But if you're holding on to that cottage and you keep it for another 10 years, that tax rate will most likely be discounted. I hope that answers that caller's question. Now I'm going to move on to one that I received again before the show. And this is about changing access and support 5 years after court. This question came in a text last week. And can you change access and support 5 years after court? And the answer is yes. In this situation, the person who sent it in says they're a divorced dad and they have joint access to their 5-year-old son. He has them what he calls the standard, Friday to Monday and alternating weekends. And he has an extra overnight on his off week. So he has 4 overnights every 2 weeks. 6 months after the divorce, he moved very close to his son's home. Does that move constitute a material change in circumstance which would allow him for more overnight access? And how likely is it for him to pass the 40% rule, as he only needs 2 more overnights every 2 weeks? Well, let me explain what the 40% rule is so everyone watching can understand that. The child support guidelines say that there's sharing of the children if each parent has the children for more than 40% of the time. And the simplest way of doing it, and it's not perfect because you can get into various arguments about how to count time, but the simplest way is if you have 6 out of 14 nights, that's 42.8%, which would mean you reach that sharing. What does sharing do for you? The guidelines at Section 9 say when you share, you take a look at both parties' incomes. So you start by looking at one side's income, what do they pay under the guidelines, and you subtract it from what the other side's income is and what they would pay under the guidelines. So you see what the difference is. It can be a significant reduction in child support. But the Supreme Court of Canada has said that's not the end of the exercise. We then have to do child care budgets, and we have to look at the conditions, means, needs, and circumstances of the parties. And when you do that, you end up with a result that could be anywhere from the way I described it, which we call the set-off, to full table child support. And that's what this gentleman is trying to do. He's trying to get to the set-off. And some of the cases say, well, just because, in this case, mom might give you an extra night or 2 nights, can create a cliff result where if their incomes are similar, mom could lose $1,000 a month in child support and therefore have to sell her home because she can't pay her mortgage. And the court's cognizant of that cliff effect to not allow necessarily the reduction in support. So this particular dad may not achieve his objective, and mom may not agree to giving him the increased time without saying you still got to pay full table child support. Now, to answer his question, is it a material change by moving closer to the home? I don't believe it's a material change because you're creating a situation. But there's also the practical reality. If you have older kids and they can walk over to your house, they may just do that. And older kids can choose with their feet what they want. And I'm not trying to encourage people to try and go on a campaign to have their children live with them, because that's not good for the kids. But the reality is that if both mom and dad live within a close walking distance, it's easier for the kids to have an open door policy with both parents, and they may decide they want more time. That may be a material change. And especially when a 16-year-old says to one parent, I want to live more with mom or I want to live more with dad, it can be a hard thing to object to because you can't necessarily send a 16-year-old child the same way you can a 5-year-old child. So a big part of it in this situation will be the age of the children. That's going to be very important. Now, another question we have is, what happens if we skip the legal process? Mike, what happens if you can't afford to get divorced? This person says he doesn't want to live with his wife anymore, but I don't think all of us can afford all the government fees and lawyer bills to get a legal separation and a divorce. They have 4 kids aged in the range of 5 to 14, and they each make about $30,000 a year. They tolerate each other, but they'd like to move on. She's agreed orally, compare what I can and see the kids whenever I want, but nothing is in writing and we have not talked to a judge. Can you offer any advice? Well, I'm going to start with, you can try to do things on your own if you want. You could apply for legal aid. We also have a website that can help you, familylawhelp.ca, which can give you some instructions on what to do. And what's important here is you can also go and figure out what child support you may have to pay on $30,000 a year. The numbers aren't big, which means that the risk factor of not having an agreement are less. And at the very least, go get an agreement done regarding what child support you have to pay. And if you want to try and do the divorce on your own, then do it on your own. Or if you want to hire a lawyer, you can hire a lawyer, because doing the divorce and divorce only is much less expensive than negotiating an agreement. I would caution you that saying you can see the kids whenever you want is highly problematic, because at any point in time, mom may say, no, you can't see the kids. And then you will need a lawyer. And then you will have a significant fight on your hands that you do not want. You don't want that significant fight. So you ought to try and get an agreement done to make it very clear what the schedule is. Now, I see that we just got another question by text. And this person says, my accountant recommends that I spend the money and have all my assets valued by a CBV before my marriage. Is my accountant trying to generate fees, or is he correct? Well, there's the best way to do things, and there is another way of doing things. And for those of you who need to understand, what is a CBV is a chartered business valuator. They're typically also a chartered accountant, but not always. Now, you don't need to get all your assets valued by a CBV, because you might have RSPs and they'll be in a portfolio and you have the statement, or you may have a stock portfolio and you have the statement for that. But if you're a business owner, do I think if you're getting married and you want to have a proper marriage contract, then yes, you should get your business valued. But that's only if you're doing a marriage contract. And the reason I say that is that a marriage contract, someone could try to say, you didn't tell me what things are worth. And because you didn't tell me, I don't like the contract. And therefore, the contract shouldn't be enforceable. So in that situation, it would be much better to get the business valued. But if you're not doing a marriage contract, don't spend your money on it. Why? Because you can get the business valued if you separate 15 years later for the date of marriage. But what do you need to do that? You need to be smart, and you need to maintain copies of your business financial statements for, I would say, at least 4 or 5 years prior to the date of marriage. That way, and I would try and keep, in fact, if you're doing it that way, I try and keep all of the business records, keep them somewhere safe and secure. I've had too many cases when clients come into my office and they say to me, Andrew, I have proof. I have $1 million investment account on the date of marriage. And I say to them, well, where is it? And they say, at home. And I say, where? And they say, in a filing cabinet. And then they phone me back an hour later to say it's gone when they get home. The other spouse destroyed it. So make sure you keep these records in a safe place so that you have the evidence and the proof, so that when you do separate, if it's 15 years later, 20 years later, 10 years later, you can actually take all that information, take it to the business valuator, and get the business valued. Why do I say to do it that way? Simple reason. A business valuation costs a lot of money. They can be $10,000, $15,000 before you blink. The other reason is, if you separate 15 years later, one of the issues is going to be, what was the value of that business? And that means you may have a battle of two valuators. You may have your own valuator, your other spouse may have a valuator, but what if the person you hired 15 years ago isn't practicing anymore? You may not be able to get that valuation report before the court because you need that person as your expert, but you can't find them. They were off in Arizona enjoying themselves, so you may have ended up paying for absolutely nothing. Now, another question is, I'm getting married in the spring, and I've built up my business for 10 years and have accumulated a lot of assets both personally and in my business. Well, this is a good reason why someone should get a marriage contract. If you want to protect your business and you want to protect your assets, get a marriage contract. It's really simple. That's what you need to do. Not to do it if you've built up assets is simply foolish, because there are certain places you can make significant mistakes. I see that we have a caller on one of our lines, so I'm going to pick that call up now. Hi, it's Andrew Feldstein.
Hi.
Hi, is that Vlad?
Yes, how are you doing?
I'm good. How are you?
Not too bad. I have a question. My wife, she has papers from her lawyer for a separation agreement.
Okay, so your wife had a separation agreement drafted by her lawyer?
Yeah, granted by her lawyer.
Okay, so you need to get a lawyer to take a look at it.
And she wants me to sign it.
Absolutely not.
I don't sign it.
You don't sign it without having a lawyer look at it. Do you fully appreciate the meaning of what you're signing? I doubt it, because you're not a lawyer. You should be protecting your rights. And if she hasn't given you a financial statement, you don't even know whether or not that's a good deal or a bad deal for you.
Well, I guess it's a bad deal. She's asking $1,000 a month for spousal support.
Well, that may be a good deal or bad deal. It depends on what you make. It depends on what she makes. And I don't know whether or not the schedule that you would be seeing your children are reasonable or unreasonable. And I mean, I can't give you an opinion over the phone because I can't give you legal advice here, and I'm not your lawyer. But if you're getting a separation agreement handed to you by your spouse, you have to assume, especially if you don't have a lawyer, it's probably going to be one-sided in their favor, and pay the money to get a lawyer to read it. And do what you need to do to protect yourself, because this may be one of the single most important agreements you ever sign in your life.
What if I really don't want to sign anything?
Don't sign it. No one can make you sign it. The alternative is she could take you to court.
She's still going to ask me for spousal support?
Sure, she could. She could take you to court for spousal support, but go speak to a lawyer. I can tell you that here at Feldstein Family Law Group, we offer free consultations. And if you phone our office during the day, we can set you up with a free consultation, or you can email us or phone after hours, and we'll call you back at a convenient time, and we can set up a meeting. Because the point here is you need to understand whether it's a good deal or a bad deal. And I'm not saying at a consultation we'll give you a legal opinion on that, but what we can do is we can provide a strategy for you of how to deal with it and what we need to in order to give you proper legal advice.
Mm-hmm. Wow. That's crazy. I never imagined this.
Nobody does. Nope. When you get married, you typically don't imagine that you're getting divorced.
Yeah, I never thought about it. Divorce.
I know. Nobody does. I know I didn't. But I'm in the same boat. And it's part.
Anything. I don't want to sign. I don't want to be separated with my kids.
But you see, that's not your choice. It takes two people to get married. It takes one to want a separation. So you can't force her to stay in the marriage, but what you can say is, I'm not agreeing to the terms that you want.
Yeah,
and I need a lawyer to look at it.
Anything.
You shouldn't. You need to speak to a lawyer to find out if it's reasonable or not reasonable, especially when it comes to the issues of your children.
And because she's going to take it to court.
So, go to a lawyer, find out if it's a deal, and negotiate. But if you ignore her, you're not leaving her with any choice but to take you to court, because you're not dealing with it.
Mm-hmm. So she's going to take me to the court if I don't want to deal with it, right?
It's very different to say, I'm not going to sign it, I'm not dealing with you, then she has to go to court. But if she had a lawyer draft it, and you go to a lawyer, and that lawyer says to the lawyer for her, I've seen the agreement, my client's not going to sign it, we want to negotiate a fair resolution, this isn't a fair agreement, and let's talk about the process, typically that's what will happen. And you can avoid court, hopefully.
Okay. But if she goes to the court, who's going to pay the court? Her, right?
She'll pay for her lawyer, you'll pay for your lawyer, subject to a judge making an order that one of you should pay the other one's costs.
Oh, okay. Wow.
Okay, so that's why go speak to a lawyer. Dealing with it and hiring a lawyer at this stage is far more cost effective than burying your head in the sand, not dealing with it, and then having a court application on your hands.
Oh my God. That's worse, right? Dealing with the court, right?
Well, you don't want to, but if somebody asks for the moon, you may have no choice. If she says you should never see your kids, then you're probably going to say, well, we're going to court, right?
Mm-hmm.
You don't have a choice.
Okay, I'll make an appointment, I guess.
Okay. Thank you, Vlad, and good luck.
Thank you.
Okay, bye. Hi, this is Andrew Feldstein.
Hi there.
Hi, is this Lisa?
It is.
Hi, how can I help you?
Oh, hi. I was wondering, currently I believe my husband will be filing a motion to change the terms of our final order. He believes that now that our son is 18, he no longer is responsible for as much child support. Our son has significant autism and lives with me full time. Since my son turned 18, I've lost about $700 a month in government funding. So I believe that I have a material change in circumstance. Now, I'm not the one wanting to go back to the court. I believe he is. I'm also on a disability pension myself, and he believes I can return to work full time. I've applied for credit splitting from the time of our cohabitation, which was 4 years prior to marriage, giving our marriage and cohabitation in total about 21.5 years. So he believes that I've done that illegally as well. I do have documentation from my specialist, my radiation oncologist, saying I'm not to return to work full time.
So let me...
I also have documentation from my place of employment at the time of cohabitation when I changed my place of residence from my parents' home to his. So he's wanting to reduce my spousal support payments.
Lisa, can you just...
He's only paid them for 2 years.
Lisa,
and
can you just...
support for my 18-year-old. My 18-year-old is still enrolled in high school. So I'm wondering if I'm in a better position as a respondent to a motion to change or as an applicant.
Okay,
if you know what I mean. Like, I really don't think he's going to be able to get what he wants.
I know what you mean, but let me start because there's lots... You've raised lots of different issues in that question.
I know, and they keep coming up.
Okay, so let's start with, he says you're employable and you're on disability. Who's paying you disability? Do you have a private insurance company or is it CPP?
Oh, Canada Pension.
Okay, so here's what I generally hear judges say. CPP does not typically pay people a disability pension unless they're disabled. So the starting presumption that's going to be in a judge's mind is that you really are disabled.
Okay.
It doesn't mean you're not going to have to give the medical evidence, but it means the medical evidence is going to be a lot easier for you to get. You're not someone who is simply saying, I can't work, because you've already qualified. And they're probably going to tell your husband that at his first conference appearance, that he's going to have an uphill battle. You're still going to have to get the evidence, but he's going to have an uphill battle. Then let's move to the second issue, which is your 18-year-old son. Is he in school on a full-time basis?
He is, and he also is in treatment, like day treatment by the Canadian Mental Health Association on days he doesn't go to school and day programming.
Okay, but you said he's in school full-time. If he's in school full-time and living in your house, that makes it pretty easy to know that just because he's 18, it's not going to be enough. Under the Divorce Act, and were you married?
Pardon me?
Were you married?
Yes, we were married in 1995 and we cohabitated 4 years prior to that.
So you're under the Divorce Act, and under the Divorce Act, if a child is unable to obtain their necessaries of life by reason of education or disability, you're still entitled to support. The only thing that happens at 18 in that situation is the court can look at it and say whether the guidelines is the right amount or the wrong amount. But when I'm hearing your son is 18, it sounds like it is the right amount, unless your son is getting some significant disability payments.
Well, that's what I was going to bring up also. From a condition point of view, he qualifies for a disability payment, but from a financial point of view, he doesn't. So no, I'm not getting anything. And in the meantime,
Okay, I'm not worried about what you've lost right now. I'm more worried about, does he get it? You've said no, he doesn't.
No,
and if he doesn't, then it means your husband should be paying table child support. And then if there are other expenses that you're paying for that are special and extraordinary expenses for his health care that are not covered by your benefits or exceed your benefits, then you could say that that's a special and extraordinary expense and your husband should be contributing to it proportionate to each of your incomes.
Right, and I do have that written in the order, which is a 70-30 split. He's 70, me 30. He refuses to do that. If he pays anything at all, for instance, for our younger son in orthodontics, he believes that his group policy that pays 50% of the orthodontics is his 50%, not the residual amount.
Typically, it should be the residual amount, and he's wrong. So you should keep all your records of this, because the problem is, if you're talking, like I know my daughter's orthodontist, I think I pay $100 a month as my share. So it's a couple $100 a month, I believe. And on that, if you're fighting about $20, $30 a month, you're not going to run to court for that. But you should keep it all together.
Yeah,
Keep
and
all
that's
the
what
records.
I've decided, that the 70-30 split in terms of orthodontics is not worth a court, going to court over. If he's going to split the residual 50-50, fine.
But keep the records on it, because if he is going to take you to court, include it. Now, you said, should you take him to court? The reality is, a lot of people will say they're going to take you to court, and they don't bother. And they could be just threatening or beating their chest and saying they're going to do it. So the question I would be asking myself is it worthwhile for me, in the sense that there's a significant upside that I'm going to get more money? So I would start with, has he given you financial disclosure of his income every year like he's required to?
Yes.
Okay. So
It's been 2 years, so yeah.
okay. So unless there's an upside for you to take him to court, don't bother. A, it's a lot of effort. B, it's expensive. C, you're going to spend a lot of time and aggravation at it. So wait for him to start it. Because what he may do is he may walk into a lawyer's office and try to seek advice from the lawyer. And a lawyer may tell him, you got a lousy case. So why should you open it up? Why should you start dealing with it unless you don't have to?
That's what I was thinking. That's, again, for the aggravate. I'm getting by.
And I will tell you, I sit, when you deal with a motion to change, the first time you go to court for a first appearance, and they schedule you a case conference in front of a dispute resolution officer. A dispute resolution officer is a senior family lawyer who will hear your case and give their thoughts about the case and try to work out a plan for your case moving forward or to settle it that day. I'm a dispute resolution officer in Newmarket, and I sit a little less than once a month. And I don't care who the moving party is or the responding party. It really doesn't matter to me. I care about the merits of the case.
Okay.
So I wouldn't do it because you think you're going to get an advantage or a disadvantage from it. I would do it because only if there's an upside in money. There isn't a tactical advantage in my view. Okay? I hope that helps.
And the fact that I've lost the Section 7 expenses that he pays are based on the monies I received from the government for my son, which now is about $700 a month less. So that's for respite. He's on a medication that has a very expensive dispensing fee, that sort of thing. Now, if I can get by, just leave it.
Well, that's a Section 7 expense he needs to contribute to.
He doesn't.
Well, he needs to. And that's something that if it's $700 a month and he's supposed to be paying for 70% of it, that's $490 a month he should be paying for.
No, $700 is what I no longer get.
And how much is the drug that you have?
For my son.
Okay,
like
and how
special
much?
services at home funding, child tax credit, disability tax, or child disability monthly allowance. So since he turned 18, all those supports financially have stopped.
But how much are the expenses you're paying for that would be special and extraordinary, like medical items, treatment, service
They're
providers?
significant at this point. Doctor's appointments downtown Toronto twice a week. Just the parking for that is extraordinary.
I get that. I can't tell you whether I think the parking is or is not extraordinary. I'd have some sympathy for that, but I'd have to think about it because it clearly is reasonable, necessary. I would ask you whether you could take the TTC. I get with an autistic child that may be very challenging.
Right.
So there's some points there, but you got to add it up and say, how much money is my upside for raising this issue?
Okay.
And is it worth it for me to do it? I would, at the very least, I would write him an email saying, I want you to pay for all these things that used to be covered, and you should be paying 70% of it, so you have a record of asking him for it, so that when you do go to court, if you do go back, you have a record that you asked for it, and he said no, because you need to ask for it in order to get it. If you don't ask for it, you're not going to get it. A judge won't order him to pay for it.
I won't get it. So, well, I just like things like glasses above and beyond our prescription or coverage. I usually just pay for it myself and don't even bring it up because everything becomes such a challenge.
I'm not expecting that he's going to cut you a check, but what I am saying is by you writing him and asking him to pay for it in advance, when you do take him to court later on, your case is much stronger to have him contribute to it
So
than
things
not
like
asking.
respite, because he's refusing to take the older boy now for his access weekends. Since Christmas time, pretty much he's not brought him overnight visits. So I need, that's 7 days a week, 365 days a year that I don't get a break. So respite for my older son, because he can't stay on his own, that would be included in the Section 7 expenses.
I think that's debatable, but again, ask him for it in writing. I know he's not going to pay it, but ask him for it.
Okay, perfect.
That's what will protect you when you go to court, because what you might do is you might wait till it reaches, now he owes me $20,000. Now it's time to go to court, and here's the proof of every request I made for it, and him saying no. At least he knew about it.
Okay. So in terms when you say proof, what do you, from a medical perspective, from my specialist, a letter from a specialist plus my file with CPP, is that significant? Like, is that enough?
Probably. I'd want to read it to see it. I mean, it's one of those things when it's enough when you see it's enough. But if you qualified for CPP, I think it's probably going to be strong enough. There's, a medical report that makes it clear when you see it.
And with regards to the CPP credit splitting, because I applied for that, I dated it back to our date of cohabitation. I have a change of address note from my employer at that time. Would that be a significant amount of proof?
For what?
Well, my husband is saying that we didn't live, he even told the judge that we didn't live together before we were married, but we did.
Now I get what your point is. That's up to CPP, what they say. I mean, how did you file your tax returns?
Well, no, I'm backing up to...
I know.
I get the credit splitting. CPP agreed. I had something notarized and I sent it in. Plus, I had the change of address form from my employer.
That's CPP.
Okay, it has nothing to do with the courts then.
It has nothing to do with the courts. CPP does what CPP does for that.
Oh, okay, and they've already deemed me like it was significant, so I'm good there then. Okay, perfect.
All right.
Okay, thank you, Andy. Have a good night.
Thank you, and good luck, Lisa. Good night.
Thanks.
Bye.
Bye.
During Lisa's call, we received some more texts, and here's one that just came in. Hi, my spouse did not respond to the lawyer's letter. We have a property that I wanted to sell in both our names. I want to sell it if I want to proceed the house sale. Should I apply for the divorce and enforce the house sale? Yes, you should. And in fact, that's one of the obvious things that's going to happen in a family law proceeding. The Partition Act says that if you're a joint owner on a piece of property, you're entitled for the sale of the home unless the other side is behaving in a malicious or vexatious way, or they have a claim for exclusive possession if it's a matrimonial home. Even if it is a matrimonial home, the house will ultimately end up sold. The only question is whether it will sell at an interim stage of a motion or at a final order. So, would I say apply for the divorce and the sale? Absolutely. However, there's one caveat you got to be really careful about in a divorce. You may want to be careful as to the timing of when you get the divorce. Because once you're divorced, you're typically not entitled to getting your benefits anymore. And that terminates the right to possession. So if you get the divorce, you may not get your benefits anymore, but the ability of the other spouse to say they want to prevent the sale of the home because of that claim for possession is lost. I see we have another text question. Oh, that seems to be the same one, came in twice. Here's one. When I started my company years ago, I put 50% of the shares in my son's name. I did this to reduce my taxes for income splitting. My son never worked in my business. My son is now going through a divorce, and somehow his wife found out about the shares. She hired a lawyer and is now coming after my business. I don't want them looking into my company. How can I stop them from looking at my company? My son has nothing to do with my company. My daughter-in-law wants to look at my companies. This is none of their business. What can I do? Well, the first answer is you should have never put the business in your son's name. That was the mistake. Now that you put it in your son's name, you got a real problem, because you're going to have to marshal the evidence to show that it wasn't his business. And that's going to be difficult, because you may have filed all sorts of paperwork and records saying you're a 50% shareholder. And if you said, and there's a line of cases that say this, that you're a 50% shareholder for the purposes of taxes, you can't turn around and say for family law, sorry, but I'm really 100% shareholder. So you would want to look at credit applications, financing applications for the business, representations made to banks, lenders, third parties as to whether or not your son was a shareholder of the business. And if you represented in all sorts of places that your son was a shareholder of the business, or your son signed shareholders' resolutions year after year after year, I think you have a real problem. In addition to that, I think your daughter-in-law is going to get access to all the books and records of your business that you don't want to give her. It's a really good question, because I sometimes speak to various accountants on this issue, and I tell them, you really have to appreciate that the moment you put any piece of your business in your child's name, you're exposing disclosure of your business to their spouse. I know I wouldn't want to do that. I wouldn't want my future daughter-in-law or son-in-law to be coming and wanting to look at the books and records of my business. That would be something that would really aggravate me. I think it would aggravate most people. And that's why I would say you need to be very, very careful, and you really shouldn't be putting businesses in children's names. Now, that's where we are in text so far. I welcome more text messages coming in at 819-307-0262, or more phone calls at 1-800-498-3486, or send me an email directly to andrew@feldsteinfamilylaw.com. Now, some of the questions that we received before the show, here's the next one. What happens if we skip the legal process? Oh, sorry, I did that one already, my bad. Next question is, I want to take my kids and move back home. My father has asked if I'll move back home to another province and help him run his business. The plan is that I'll take over in a few years when he retires. He knows I'm not particularly happy in my marriage, but I've been willing to hang on because I did not really have anything else to do. We have 2 kids, 11 and 12. My dad says he thinks that my running a successful company will be more important for his grandchildren than me staying in Toronto and not being very happy. I have several main questions. Am I allowed to move back to the Maritimes and take my children with me? Is it necessary to bring my husband? If I move back east and my husband stays here, will he have any rights to my dad's company when he passes it over to me? Do I need to pay my husband's expenses when he comes to see the kids? I think that after a few years at the family company, I'll make more money than my husband. Will I need to send him money? These are really good questions, and let's begin with the first part, which is moving back to another province. If you're still married, the two of you can jointly decide to take your children and move to another province. If that happens, you're in great shape, because what we look at is the status quo, meaning what's the situation when the parties separate and what's the habitual residence of the kids. So if you separated and you're living in the Maritimes and the kids are living in the Maritimes, the status quo is living in the Maritimes. The habitual residence of the kids, where they're living, is in the Maritimes. That's easy. It's really, really hard if you separate and you say to your spouse, when you have an 11 and 12-year-old, I want to move to another province. I think in this situation, and this is the husband who is remaining here in Ontario, you're going to have a fight. You're going to have a very big fight. And the advice I give to clients, the leading case is a Supreme Court of Canada case called Gordon and Getz. And at the end of the day, Gordon and Getz takes you through all sorts of tests, but it really boils down to what's the values of the particular judge hearing the case on that particular day. And these kind of mobility cases are really, really hard. They're challenging because there isn't that much room to settle, because both sides have differing opinions. And if you're the parent who's here in Ontario, you feel like you are losing your children. And that's something that will make you fight, and make you fight very hard. Now I'm going to take you through these questions. She says, is she allowed to move back to the Maritimes and take her children? The answer to that is, it's a maybe. Is it necessary to bring her husband? Well, if you're still together, it's a good idea, because that may help get you there. Next part is, if I move back east and my husband stays here, will he have any rights to my dad's company when he passes it over to me? Well, if you have separated and now you're living in the Maritimes because you moved there post-separation and he's here, then the best he can do is he can try and say that you have a big income stream or a bigger income stream coming in and claim spousal support from that income stream. If he moves with you and you stay together and live in the Maritimes and then separate, then depending on what province you're in, you're going to be living under their laws. And that may have significant consequences. I can't answer what the questions will be because if you're living in Nova Scotia, then you're going to be living, if that's where you are, together as husband and wife. The property regime of the province of Nova Scotia would apply. Do I need to pay my husband's expenses when he comes to see the kids? Now that's an interesting one because sometimes when one party permits the move, you incorporate into the deal who has to pay for the travel, what happens with the travel expenses, and who has to pay it. So this is the type of thing that happens more by negotiation than by court order. And she says, after a few years at the family company, I'll make more than my husband. Will I need to send him money? That's possible. You might. But he's going to be paying you child support for a number of years, and it may just offset some of the child support. Now, another text just came in. And this text is, my girlfriend wants to move into my house, which I've owned for years with her 3 children. We plan on getting married this fall. If somehow we get divorced in the future, am I responsible to pay child support? Great question, and the answer is maybe. There's a Latin term called loco parentis, and it means demonstrating a settled intention to treat the children as your own. And if you demonstrate a settled intention to treat the children as your own, then that means you may be called upon to pay child support for those children. And it could be less than the guidelines or all the way up to the guidelines. In some cases, they will look at what the table child support that's being paid by the biological father and say you have to top it up to whatever the adoptive, or not adoptive, but the step-parent has to pay. The problem here is it shocks people to find out they may be paying for children that aren't their own, as well as university expenses for those children. You may be called upon to contribute to that. But what creates demonstrating a settled intention to treat the children as their own? There's certain things that are obvious. If you have a 18-year-old, 16-year-old, and 14-year-old moving in with mom, and those 3 kids see their father every other week or 4 or 5 times in a 2-week period of time, I don't believe anyone is going to say that you've really demonstrated a settled intention to treat those kids as your own. Let's contrast that with a 4-year-old, a 2-year-old, and a newborn, and they're moving into your house, and the biological father's out of the picture. That's a pretty easy one that if it's 15 years later or 10 years later, you're going to be seen as the parent and you're going to be paying. Now, I've always said extremes are easy examples to show. Those are the easy cases. But there are hard cases, and those are the ones in between. And those can be maybe. And can a marriage contract protect you from that? Well, you can reflect in a marriage contract that the person who is the step-parent is not demonstrating a settled intention to treat the children as their own. You can put that in. The downside is, at the end of the day, the court always has the right to make an order for what they say is in the best interest of the children. In this case, what's in the best interest of the children? It may be the child support to be paid. So there's questions, there's variables, and in family law there's frequently a lot of gray. And that happens to be a gray area. I hope that helps the person who sent in the text message. I'm going to flip back to some emails that came in before the show. And this is obligations when one spouse is incapacitated. This isn't my real situation now, but I'm curious and worried. I think lots of people really do have this problem, or they will eventually have this problem. What obligation does one spouse have if the other one is unable to look after himself or herself and they are still married? Maybe the husband has Alzheimer's or the wife is in a coma. Can one spouse divorce the other or live with someone else? If both spouses are healthy when the couple gets divorced and a few years later one of the former spouses becomes incapacitated, does the other ex-spouse have obligations? All really good questions. And I'm going to start with, in my career, I've never seen someone get a divorce while their other spouse is suffering from Alzheimer's or in a coma. And there's a few practical reasons why I think that's happened. Number one, if it's been a long-term marriage and you have kids together, think of the message you're sending your kids. Your kids are going to be angry with you. Number two, if you decide to divorce them, you're going to have to give them an equalization payment, and you may have to make support payments. It may be far cheaper to pay whatever the health-related expenses are than to go through the process of a divorce. So it really doesn't make any sense, potentially, to get divorced from an economic perspective and really from a moral perspective. Can one spouse divorce the other or live with someone else? Well, they can, but quite frankly, if one spouse is in a coma or has Alzheimer's, even if you are married, it doesn't stop you from living with somebody else while you're married, and you might end up living with someone else while your former spouse is in a coma. May not make people happy to hear that, but that's the reality. It's an option. And then the next question, if both spouses are healthy when the couple gets divorced and a few years later one of the spouses becomes incapacitated, does the other ex-spouse have obligations? And the answer is maybe. They may have to pay spousal support. You need to look at the Divorce Act, and there's some leading cases from the Supreme Court of Canada on that issue, and it's certainly a risk. Certainly if it's a long-term marriage, say people are married for 20 years, the likelihood of providing spousal support is going to be significantly higher than a short-term marriage. So there's various factors that you need to look into at that point. Just have a couple of another text question that just came in. Okay, it says, I don't practice my religion. My ex-wife wants a Jewish divorce called a get. Can she force me to have a get and pay for half of it? I'm not religious and I only had a Jewish wedding. I like that question because it's interesting. The Family Law Act and a family court judge can make somebody go and get a religious divorce. They can. The fascinating thing I found when I went for my get with my former spouse was the first thing the rabbi asked was, did a court force me to be there? And I was really intrigued by that question because I knew the courts can do that. And I said to the rabbi, no, I was happy to be there, but I know a court can make that order, and if I had said that a court had ordered me to be there, what would they do? And the rabbi told me he wouldn't give me the get. So it's an interesting situation where a court, in a civil court, can order you to go get the get, and if you admit to the rabbi that you're getting the get to, that you've been ordered there by a civil court, he'll refuse to give you the get. So technically the answer is yes, but what happens at the end of the day, I'm not really certain if I had gone and I had given that as an honest answer, how that would have played out. So it makes for an interesting problem. I think we have time for one more question right now that came in by email. And this one is, my husband and I have agreed. We don't want to be together anymore, but we don't understand some of the definitions. I think we want a legal separation, and he says we want a divorce. But I read somewhere the only reason to have a divorce is so you can get married again. What happens if you just want to live with someone else? Isn't that common law marriage, and aren't common law marriages legal too? Can you help us understand? If it makes any difference, we have one boy who is 9 years old. So I'm going to start with, a separation is when parties, and there's different definitions. In the family law, you're living separate and apart when there is no reasonable prospect of resumption of cohabitation. The Divorce Act is different. You can actually reconcile for a period of up to 90 days, either consecutively or not consecutively, and still be considered separated. When you get separated, that's when you can enter into a separation agreement, and the separation agreement will deal with all of the important issues such as custody, access, child support, spousal support, and property division. That can all go in a separation agreement. When the person says, well, the divorce only means you can get married again, the divorce also has implications, like I said earlier, about benefits. And quite frankly, as someone who at one point, I was single after I got divorced, I found you were much better off if you said you were divorced than if you were separated. People always felt that when you're separated, you still have one foot in your former marriage and that you might reconcile. So that isn't a legal issue, but it's a practical issue. So living common law, some people may not want to. And they are different because a married person is entitled to division of that family property. A married person is entitled to possession of the matrimonial home. A common law person does not have entitlement to equalization of net family property, which is a division of assets, does not have a right to possession of the matrimonial home, and has no rights until they're living together for 3 years or they have a child together. A common law person could make a claim for beneficial interest in assets, but that takes time and they have to be able to show what they've done. In terms of the 9-year-old boy, the significance of that is if they want a divorce, they need to make sure that reasonable arrangements for child support are in place. Now, that's all the time we have for dealing with the emails. I have a stack of emails here that I didn't get to tonight, unfortunately. I enjoyed the calls that came in and the text messages that came in, and I've appreciated what people are asking these questions. And I know some of you may decide to watch the show on our YouTube channel as a recording. And now I want to say we are coming to the end of our show. We're just about out of time. I think it's been a great show. I want to thank all the people who asked the questions, whether it be by email, text, or phone. Not only did you have interesting questions reflecting your own lives, but I know that many of the people in our internet broadcast audience found lessons for their own situations. We'll be back in March with the next Ask Andrew show. Please remember, if you have questions about family law, we have 3 websites that offer you the most up-to-date free information. And you've probably heard the saying, information is power. We invite you to learn about your rights and obligations during your divorce. Separation.ca is the main Feldstein Family Law Group website. It has explanations of the process of working with us on a family law matter. Plus, it has many articles and blogs, including videos that explain various aspects of family law. It's a fact that this is the largest website on family law in Canada, and I can tell you we have worked incredibly hard to make it something that we're very proud of and that many people visit daily to gain their information. We have hundreds of pages, we've worked hard, and we try to keep it up to date with information if the law changes. Many people have worked very hard on it, and I believe it's reflected there. Visit our site, separation.ca. We have another site, familylawhelp.ca. This site explains the entire divorce process and is designed to help visitors who might want unbundled family law services. Unbundling is a process where someone looking to get separated or divorced does some of the work themselves and asks a lawyer for help on other parts. An unbundled services client might, for instance, draft agreements explaining how they want a settlement proceed and then pass it to a divorce lawyer for a review. Or you might determine what points you want to make to a judge, but ask an experienced lawyer to actually stand up for you in a courtroom. That's familylawhelp.ca. And our third website is designed to improve access to justice for everyone going through separation and divorce. Access to justice is a phrase we use when talking about cutting costs, cutting time, and cutting through the bureaucracy in family law. I've published 2 white papers and we've received many comments about how they help build the understanding of why costs are high and what can be done to reduce them. A third paper about the difficulties of representing yourself in family court will be published this year. The site is called itsTimeForJustice.ca. Thank you for tuning in tonight. Good night, everyone.